History as it happens, May 12, 2022. Our endless free speech wars.
The deal is done. Twitter has been sold to Elon Musk.
Accepted an offer from the billionaire to buy the social media company and take it private.
Celebrating with rocket emojis, tweeting in part, free speech is the bedrock of a functioning democracy, and Twitter is the digital town square.
Elon Musk is vowing to restore free speech to Twitter, ending the censorship, as he sees it, that deplatforms such figures as Donald Trump. But his acquisition of the social media site caused an uproar on the left, as some feared Twitter could turn into a free-for-all of disinformation and conspiracy theories, as if it weren't bad enough already. So how much speech is too much speech? That is the question. Next, as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
I think he's in for a rude awakening. We're back to this whole boundaries thing. He says he wants to open up Twitter to the constitutional boundaries. And if he does, that will be interesting. I think there's going to be a lot of garbage. There's going to be a lot of misinformation. There's going to be a lot of disinformation. There are going to be conspiracy theories that are floating all around.
In March 2021, Jack Dorsey, then the CEO of Twitter, testified before Congress. His opening statement might go down in history for exemplifying the impossible situation of social media platforms during this fractious time.
We believe in free expression. We believe in free debate and conversation to find the truth. At the same time, we must balance that with our desire for our service not to be used to sow confusion, division, or destruction. This makes the freedom to moderate content critical to us.
Can speech be free and moderated at the same time? Twitter's new CEO might say no. Elon Musk has criticized the social platform he now owns for censoring people. Censorship is a dirty word in American society, something that no true American could ever support, right? Well, Twitter does have its own First Amendment right to block content it finds objectionable, and here are a few examples according to an Associated Press article. Twitter said Donald Trump's tweets amounted to glorification of violence when read in the context of the Capitol riot and plans circulating online for future armed protests around the inauguration of President-elect Biden. That same article goes on to say the long list of people banned from Twitter includes QAnon loyalists, COVID deniers, neo-Nazis, and former reality star Tila Tequila, who was suspended for hate speech. Other Trump allies kicked off Twitter include Michael Flynn and Sidney Powell, the article says, Lynn Wood and Representative Marjorie Taylor Greene. She was permanently banned for repeatedly spreading misinformation about COVID-19 and vaccine safety. And that same article says other white supremacists and conspiracy theorists have been banned from Twitter. Now, plenty of people out there might be okay with that, maybe you listening to this podcast, who do not want this stuff or those people on Twitter ever again, and maybe you have a point. The site would be even more toxic than it is now. But we should note it's not really clear yet how Musk is going to approach each of the aforementioned cases, except that he has already said he will lift Donald Trump's ban. No one has a First Amendment right to post on Twitter, Facebook, or YouTube, no more than anyone has a right to force a newspaper to carry their guest op-ed. But free expression is a cultural value too. It's not only a First Amendment issue. So whenever I dip my toes into this debate, I think of something Noam Chomsky said to French students decades ago, after Chomsky had been assailed for defending the right of a French Holocaust denier to publish his false claims.
But I'm saying if you believe in freedom of speech, you believe in freedom of speech for views you don't like. I mean, Goebbels was in favor of freedom of speech for views he liked, right? So was Stalin. If you're in favor of freedom of speech, that means you're in favor of freedom of speech precisely for views you despise.
And then, as Chomsky put it in an interview on C-SPAN in the early 1990s.
Well, I'm personally very skeptical about any form of regulation of any kind of speech. Now, the media don't even begin to approximate freedom of speech. I mean, this is the kind of freedom where people who own the place set the rules. So that's not real freedom. Nevertheless, the idea of, even in that kind of system, heavily skewed towards extreme wealth, personally, I'd be reluctant. I'm very reluctant to see any kind of regulation take place. Freedom of speech is a really important value. Over the centuries, particularly in the United States, won a lot of one substantial freedom of speech, and I think we ought to preserve it.
And as far as I know, the rise of the internet has not made Chomsky change his position on the importance of free expression in speech, the arts, academia, to a healthy democratic society. For most of our history, the First Amendment was a battleground too, meaning it was not a given from day one that all speech would be protected from government interference. Remember the Sedition Act from your high school history classes? That made criticizing the John Adams administration illegal. You would definitely remember it if you were alive in the 1790s. But even in the 20th century, the Supreme Court issued rulings in favor of the government. During the First World War, the Wilson administration threw socialists in prison and shut down the socialist press. In 1919, in Schenck versus the United States, the court upheld the conviction of socialist Charles Schenck. He had been charged with violating the Espionage Act for trying to discourage draftees from going off to fight in the war. In that ruling, Justice Oliver Wendell Holmes introduced the clear and present danger test. That meant if your words were used in such circumstances and are of such a nature as to create a clear and present danger, he wrote, that they'll bring about the substantive evils that Congress has a right to prevent, like plotting to overthrow the government or incite a riot. In another major case later that year, Holmes dissented when the court upheld the convictions of 5 anti-war petitioners because, in his view, their speech did not constitute a clear and present danger. And it took until the 1960s for the court to strike down once and for all seditious libel laws. And in 1978, maybe the most famous case of all, at least in modern times, the ACLU successfully defended the right of Nazis to march in Skokie, Illinois. So that was a lot of history right there, but the point is, it took time to reach our current expansive view of the First Amendment. The internet is still relatively new. Twitter and Facebook haven't been around for all that long. Maybe it'll just take time to work this out, to reach a cultural equilibrium. In 2019, in a speech at Georgetown University, Facebook chief Mark Zuckerberg tried to explain where that middle ground might lie.
Now, I believe that people should be able to use our services to discuss issues that they feel strongly about, from religion and immigration to foreign policy and crime. And I think you should even be able to be critical of groups without dehumanizing them. But even this it's not always straightforward to judge or implement at scale, and it can often lead to some unfortunate enforcement mistakes on our part. Is someone reposting that video of a racist attack because they're condemning it? Or are they glorifying it and hoping that people copy it?
But as we know, it's been hard finding the right balance between freedom and moderation. It always has, it always will be. Lynn Greenkey is an attorney and a professor at Syracuse University's Department of Communication and Rhetorical Studies. She's an expert on political and legal discourse, and she's out with a timely new book, When Freedom Speaks, The Boundaries and Boundlessness of Our First Amendment Right. Lynn Greenkey, welcome.
Thank you, Martin. Nice to be here.
I'd like to thank you for being willing to wade into this thorny subject with me. Was there a particular issue or controversy that inspired you to write about this enormous issue, or was it just a general interest?
It is an enormous issue. And the reason I wrote the book is because I firmly believe that knowledge of our constitutional rights, particularly our right to speak freely, shouldn't belong only to the educated elite. I think it should belong to all of us. So I wrote a book that treats the First Amendment like a series of stories, because that's what they are. They're a series of stories. Someone did something and it often landed them in jail. And they argued that they were exercising their constitutional right of free speech. And from that, we developed what I call in the book, the boundaries and the boundlessness of that right. And I purposely wrote the book to be readable for those that don't have a knowledge or background in our Constitution and have no desire to wade through a 1,000-page treatise or complex legal language. I wanted to make it accessible. I wanted to make it so that we could all discuss and debate our First Amendment rights from a level of knowledge.
Your book mostly deals with legal issues, First Amendment, specific First Amendment cases and issues, but free speech also has a cultural quality, if you will. I want to live in a society, I don't know about you, where free expression is a cultural value, not just a First Amendment, government may not censor you issue.
That's such an important point. And it's a point I make in the book. It's a point I make in my discussions, that too often people do not distinguish between moral speech and constitutional speech, that the universe of moral speech is actually pretty small and well defined. The universe of constitutional speech is much more vast. While it may be immoral to spew hate speech, it is constitutional. And I think when we don't create those boundaries, we don't recognize those boundaries, when we conflate those boundaries, that's when we get into trouble, because we say, you can't say that. Well, yes, you can. You may not like it. It may make you angry. It may make you uncomfortable, but you have every right to say that. And I think we need to learn. And again, that's one of the things that I tried to do in my book is say, okay, hate speech is really disturbing, but it's constitutional. It's protected, except under very, very limited circumstances.
Well, that's where the battle is taking place in American society today, not in the government realm, so to speak. It's in the cultural space, and there the enforcement mechanism, well, it's hard to know where it is. On college campuses, shouting down or disinviting people with whom you disagree. Online, we have cancel culture. We have Twitter deciding to kick people off its platform. We're going to get into all of that. But let's start with the First Amendment itself. A single sentence in the Bill of Rights. So I guess it should be no surprise that we've been fighting over what that one pretty generally phrased, vaguely phrased sentence means, right?
Absolutely. It is vaguely phrased, and it requires, as does every element of the Constitution, interpretation. And that interpretation has changed over time. It was much more restrictive when the Bill of Rights was first ratified. And it is only really since the middle of the last century that we have had such a vast and broad definition of our right to free speech. I like to talk about it as, from that point on, our way of thinking about the First Amendment, a way of thinking about our right to free speech, is that the default option now, since the middle of the last century, is to protect speech. That if we're going to limit or punish speech, it is for very compelling reasons, whereas that wasn't necessarily the case when the Bill of Rights and the First Amendment was first ratified.
The Constitutional Convention, 1787. The Alien and Sedition Acts, 1798. So right from the beginning, we have the government basically abrogating the First Amendment. The Sedition Act made it a crime for the Jeffersonians to criticize the Federalists. What kind of insights do you offer about that case, and why was that important?
The truth is, the Sedition Act did not last very long. I think it was a little over a year. Today, in fact, the Sedition Act of 1798 is generally remembered as a violation of First Amendment principles. So it really doesn't have much of an impact on our world today. As I said, since the middle of the last century is really the First Amendment as we know it today really became in force at that time.
As a result of the Sedition Act, some critics of the Adams administration were actually thrown in jail. Some people had their newspapers shut down, if I'm not mistaken. But it was legal to criticize the vice president, who was Thomas Jefferson.
Yeah, correct.
But in the early 20th century, Woodrow Wilson shut down the socialist press and had socialists thrown in jail for railing against U.S. involvement in World War I. In some cases, people made the case that it wasn't a free speech issue, it was a national security issue. Therefore, you don't have the right to say certain things.
In 1919, there were just a series of cases about, that was when the concept of the clear and present danger developed. And indeed, there was this sense that it's actually a communication theory. There was this sense that the polity could be affected by speech. This is an interesting sort of analogy in today's world, but in the same way that a vaccine affects the polity, like everyone responds to it the same way. It was called the hypodermic needle theory or the magic bullet theory. And so there was this sense that audiences really react in sort of this monolithic way. Since then, communication theory has developed, and we know that that's not really so, that audiences come with disparate understandings and reactions to things. It's now called the limited effects theory. So now there is a more nuanced understanding of the audience. But it was actually during that period, when you're talking about in the Woodrow Wilson period, that Justice Holmes authored a dissent dissent in the Abrams case. And that's when the whole concept that speech should only be restricted or criminalized in very limited circumstances. So it started in his dissent, and that dissenting view grew over the next 50 years till it actually became law in the Brandenburg case in the 1960s, which interestingly protected the speech of a Klan member.
Your initial answer, you referenced our current expansive view of types of speech protected by the First Amendment. That really comes into play in the mid-20th century. So laws against seditious libel weren't struck down by the court until the 1960s.
In the Brandenburg case in the 1960s, the court developed a doctrine in which they indicated that this was an incitement case, which is also sort of interesting given the January 6th issues that occurred. But the issue there was that people who are talking against the government should be allowed to talk against the government, and that was called advocacy. You can advocate against the government. What you can't do is incite. So there's this sort of continuum, and there's this test that one has to apply. And the test is, was there an intent to cite? Was this an incendiary situation that was likely to result in incitement? And it's pretty limited that, again, you can advocate about overthrowing the government, but you can't move people to do it. You can't incite them to do it. And those are the cases that you're referencing.
I'm glad you brought up January 6th, because there is a debate right now about whether Donald Trump was guilty of incitement. He didn't go up there and explicitly tell the mob, go down Pennsylvania Avenue and beat people's heads in. But he came close to that.
Well, I think that's an interesting debate. I think you're correct. I think my personal feeling is that those people who attacked the Capitol came ready to rumble. And Donald Trump could have said to them, have a good morning, go ahead and walk down to the Capitol. And they still would have besieged the Capitol, and they still would have broken windows and defecated on the floors and all the awful things that they did do. So did Donald Trump's words incite that mob? I think they were ready to go before. And if we are going to stick to the doctrine that the default option is to protect speech, then I don't think, my personal belief is that Donald Trump is not responsible for inciting that riot. They were going to do it no matter what.
In part because he and his allies had been riling people up for weeks and months beforehand, saying the election was stolen, your country is being stolen. But I do tend to agree with you. It's hard to pin down this, right, in the language that he used. What is incitement? That's
a very interesting point that you bring up. This concept of when does incitement occur, that Brandenburg test that I told you about, that there has to be an intent to incite and has to be an incendiary situation, which is likely to incite. One of the elements of that is that the situation has to be imminent, that the words have to imminently incite the group to go and do illegal things. The issue here is and remains that social media is asynchronous. I send a message and you receive it when you receive it, correct? This concept of imminence is really, really attenuated. So the question is now, does that doctrine have to be somewhat modified to reflect the realities of social media? If that is the case, then those people that discussed going to the Capitol and discussed the fact that they were going to be armed and discussed the fact that we really have to stop the transfer of power by force.
Stop the steal.
Stop the steal by force. What's happening now is that the people that were talking about stopping the steal over social media will say, hey, it's my First Amendment right to advocate that we should stop the steal. The issue is, can we now say, no, your First Amendment right stopped at the incitement, and you weren't just advocating about stopping the steal, you were inciting to stop the steal. But again, that imminence concept, it doesn't work right now.
I'm glad you brought that up, because I'm often surprised when I speak to young people, especially young people on the left who have no knowledge of the 1978 Skokie, Illinois case, where the ACLU argued in court that you may not say this group's speech is going to cause violence, because then you can say that to prevent almost anyone from organizing a parade, a rally, a protest. I think where this issue is really thorny is when it's used to preempt speech that you do not like. Do you agree with that?
This is so interesting that you bring that up. The reason I fell in love with learning about the First Amendment was I went to my undergraduate degree, and I have a master's degree also from Northwestern University. And at that time, I took a class by the late Franklin Hayman, and he was actively involved in the Nazi march in Skokie with the ACLU, defending the Nazis. That was part of my introduction. So interesting that that's the case that you bring up, because that's my personal history with the First Amendment, fell in love with it with him. And yes, you're talking about this concept of prior restraint, that we should not stop speech before it happens, that we can stop speech if things are going to happen, that incitement issue, again, that imminence, is it going to happen? Can we stop speech then? But stopping speech before it happens is absolutely abhorrent to the First Amendment.
I think it's also abhorrent to a cultural value of free expression. We're going to get to that. I want to backtrack to a question I wanted to ask, but we went right on into the 20th century, so I didn't want to disrupt the flow of the conversation. Prior to all this, the federal rights protected in the Constitution and the Bill of Rights did not apply to the states. I think a lot of people are surprised to learn this, that it took a while to establish this idea that the federal government, and specifically the Bill of Rights, protects your civil rights regardless of which state you happen to be in.
What a timely topic right now, right?
Yes, with Roe versus Wade, yes.
Given Roe versus Wade. What you're talking about, the name of the concept that you're talking about is called the Incorporation Doctrine, which incorporated most of the Bill of Rights as applicable to the states through the Due Process Clause of the 14th Amendment. What you're talking about is this concept of federalism was an issue in the Constitutional Convention and has remained an issue throughout. And it is exactly as you say, which governmental entity should have the power to legislate over a particular population, which rights are so fundamental that they belong to all of us equally, independent of zip code. And that's been a fight since the birth of our nation, where the states have wanted to maintain as much control as possible. And the federal government says, no, we need to have some uniformity. Today, as we sit here today, those are the debates that are going on with regard to overturning Roe versus Wade.
My listeners probably know that my position on this is I'm a near absolutist when it comes to free expression, not just from a strict First Amendment reading, but culturally as well. I'm uncomfortable with almost all forms of censorship or shutting speech down. Do you remember when Mark Zuckerberg spoke at Georgetown in 2019? Do you remember that speech?
I do.
Did not age well, as the kids say these days. He pledged Facebook would protect all forms of free expression. It was there for the marginalized and the weak so they could have a voice in society as well. He said he didn't want Facebook to be the arbiter of what's right and wrong, true or false online. What happened there?
Well, I mean, Facebook is not a government entity, nor is Twitter, nor is Instagram. They have their own First Amendment right to edit material that's on their platform. And they have exercised that right. They can monitor speech. I mean, it does reduce the marketplace of ideas, but once again, they are not a governmental entity and they can go ahead and do that.
But why do you believe they came under so much pressure to start moderating content when their initial desire was to not have any real moderation?
It was political pressure. And again, I think we're back to this concept of let's not mix the boundaries between moral and constitutional speech. And I think that's exactly what's happening. People do not understand that constitutional speech is vast and broad, but the concept of moral speech is not, and that immoral speech is often constitutionally protected. Nonetheless, these companies are not governmental entities. They have editorial rights. They have their own First Amendment rights. They are exercising them.
Not very well, though, would you agree?
I think that's a matter of debate. It really depends on where you fall on the political spectrum, right? I don't think there's a definitive answer to that. It really depends on who you are and who you vote for.
Yeah, there are no easy answers here. You're right. Maybe I should ask you, what is your view on free expression? I mean, mine is near absolutist when it comes to the First Amendment and also the cultural, societal value of free speech. What's your position?
I agree with you. I often say We have done a very, very poor job of educating our polity, our kids, on civics. They just don't understand exactly what I've been saying over the course of our conversation, this concept of moral versus constitutional. We've done a very poor job of that. We've done an excellent job, I think, of infusing our kids with this sense of morality. But what happens is, because they're young, that often will translate into intolerance. And so they're intolerant of ideas that they find abhorrent. And I think that we have to explain to them that intolerant ideas also expand the marketplace of ideas, that we need to listen to all and debate all of the various positions that people take in order to find the truth and in order to find the best way that we can deal with our government and our polity and our culture.
I have to say, though, my own views, I have questioned them only because of the way the internet works, right? Bad information, misinformation, disinformation can spread so quickly. But, shutting it down doesn't necessarily work. It's not necessarily effective. I mean, just look at vaccine content, right? Facebook, YouTube, Twitter. They will not allow people to go on their platforms and spread garbage information about the vaccine. Hasn't stopped people from thinking the vaccine doesn't work.
Right. Well, I mean, Europe right now just passed a really extensive legislation which requires all of these companies to monitor content. So it is going to be very interesting. They're doing this first. It'll be interesting to see how it rolls.
Well, they're not very good at it. I mean, take the Hunter Biden story, right? Now, I personally don't care very much about Hunter Biden, but it was a story. That laptop situation prior to the election was real. Twitter censored that story, and that was actually censorship. Did not allow it to appear on its platform. Now, the New York Post still published it on its own, but it wasn't allowed to spread on these public utilities, as some people call them.
They're not a public utility. As I've said, they're not government owned. And I like to use the word censorship as applied to the government. The government censors. These companies edit. They are expressing their editorial power to publish or to not publish. That's what they did, right or wrong. And of course, we can debate whether that was right or wrong to do. But because they are not the government, they can use their editorial powers. So I don't think it was censorship because it wasn't the government. Had the government done it, it would have been censorship and, in fact, unconstitutional.
I think one problem here is there aren't enough platforms. It's basically Facebook, Twitter, Instagram, YouTube. Donald Trump tried his... what was that? Truth Social fiasco, of course. Why do you think so many people on the left, and I know I'm generalizing here, but younger people on the left no longer value the primacy of free expression, academic freedom, all these campus wars? I know it's easy to overstate the case because controversial people speak on college campuses all the time and you never hear about it. But it does seem to be an issue right now.
I think you're right that the case is overstated in the media, to be honest. But I think it's, again, what I had said. I think that they're young. I do think we've done a terrible job of educating them about civics, so they don't understand the boundaries and the boundlessness of our First Amendment right. But we've done a phenomenal job of teaching them morality. But in youth, that can translate as intolerance. And I do think that there is a level of intolerance for views that don't match my own. Yeah. And I think that that's where this is coming from. There are two things we need to educate our kids on. First of all, like I said, those boundaries between moral and constitutionality. And I think they need to understand that indeed the default option is to allow speech. And the reason we do that is to expand the marketplace of ideas. And what they are doing is restricting it. That's not a good thing for democracy.
They're using the prior, whoever that might be, the prior restraint argument without actually knowing it. They're saying speech is violence. Well, they also say silence is violence. Make up your mind. What are your thoughts on Elon Musk acquiring Twitter?
Elon, well, I think that he is a very wealthy and very smart man, but that doesn't mean he knows everything about everything. But it's looking like there are a lot of investors that seem to believe that he does. He's just gotten a ton of investors to support him. I think he's in for a rude awakening. We're back to this whole boundaries thing. He says he wants to open up Twitter to the constitutional boundaries. And if he does, that will be interesting. I think there's going to be a lot of garbage. There's going to be a lot of misinformation. There's going to be a lot of disinformation. There are going to be conspiracy theories that are floating all around. I think this may push the Congress to modify Section 230 of the Communications Decency Act, which currently makes these platforms immune from third-party liability. In other words, if I publish something on Twitter that defames you, you can sue me, but you can't sue Twitter, right? I think if any of these platforms, if they just have a free-for-all, that there is a possibility that that's going to move Congress, particularly if it remains Democratic, maybe even Republican too, I'm not sure. But I think that may move Congress to take a look at 230 and say, hey, there is going to be some third-party liability here. And that's going to be expensive.
Well, Twitter is already a terrible place. Most people do not use Twitter, but it seems to have this sway and influence in society, punching above its weight, so to speak.
Well, politicians use it, and policy wonks use it a lot.
Yeah. I mean, it is important. I don't like Twitter, but it is an important platform. Yeah. And when it comes to editing or content moderation, if things go sideways once Musk is in charge, why can't we just tell people, well, stop using Twitter. If you don't like it, don't go there anymore. People push back on that argument, though. They say, well, where else am I going to go? It's Twitter, Facebook, YouTube, Instagram. There aren't many options.
Back to the same thing you mentioned before. There aren't many options. That, however, is an economic argument, right? And that maybe they can be considered monopolies. And again, maybe it's up to Congress to, like they broke up AT&T decades ago. Maybe it's time to reduce the monopolistic power of these platforms to allow other platforms to grow. And then there'll be more competition.
Anything surprise you as you were researching your book that you didn't know about this issue that you think people should pay attention to?
I think what struck me, and again, I wanted to write about stories. So reading about the people as human beings and how this has affected their lives struck me. And it was just interesting to see some people went on to teach in the philosophy department. Others really just faded into the background. There are stories about what attorneys thought of their clients in that Brandenburg case. Their attorneys really didn't like their clients very much and said some disparaging things about them. So it was just interesting to learn about the context and the history.
Well, I'm glad I spoke to you because I want to read up on the Brandenburg case. I'm not all that familiar with it, just looking online here. You referenced it before. A Klan leader made a speech at a Klan rally, but then was convicted under an Ohio criminal syndicalism law.
Yeah, say that 3 times fast.
Yes.
He was. Yeah. And that was part of what we had talked about. Those are from the clear and present danger line of cases. The states decided to incorporate that into their legislation. And ultimately, those laws went by the wayside. I think the last one was in the 1990s, to be honest. And I think it was in California, believe it or not. We can thank this concept of we can advocate for violence as opposed to incite violence. We can thank a Klanner for it, believe it or not.
Maybe that's the only thing. Maybe.
But isn't that interesting? And that was when you said what was interesting. Well, that's interesting.
Well, we don't need the First Amendment to protect positive or popular speech. It doesn't exist for that reason.
Exactly. It exists to protect the disturbing speech and the speech that angers us. And speech can anger us and be disturbing and make us sad. It's still protected. It may not be moral, but it's still protected.
And the marginalized. They will suffer if more power is given to the powerful to regulate speech anymore than they can at the moment. Lynn Greenkey, we thank you for writing your book, When Freedom Speaks, and for coming on the podcast. On the next episode of History as It Happens, we're going to return to our occasional series, Slavery and the Constitution. We'll be joined by historian Kate Maser, whose book, Until Justice Be Done, was a finalist for the Pulitzer Prize this year. That's next as we report History as It Happens, a podcast from the Washington Times.